We speak to constitutional law expert Pierre de Vos now. Very good evening to you, Mr. de Vos, and thank you so much for speaking to us. So the Constitutional Court and its purview over this matter was always the case. So I'd imagine for you that this is no surprise that the court has found in the manner it has.
Well, it was a difficult decision because either way, really, the court was put in a very difficult position. The fact that the Constitution actually requires the election to happen by the end of October, beginning of November, made it very difficult for the court because they were really required to undo the Constitution. So in that sense, we'll have to see, wait for the reasons, but in that sense, it seems logical, although I also note that the decision was not unanimous, so there were some judges dissenting in the matter, but we don't know at the moment.
Okay. So there was the option of going to the Constitutional Court, but there was also the option of going to Parliament. For expediency's sake, the IEC decided to go to the Constitutional Court. Does it then have, and of course, obviously it's a matter of timing, which isn't there, can it go to Parliament on an urgent basis?
It cannot go to Parliament in the sense that it will require an amendment of the Constitution, and there's not the amendment of the Constitution. There are prescribed time periods for an amendment. You cannot rush it through. There has to be consultation. So it cannot be done in time. If they wanted to go to Parliament, they should have gone much earlier in the year. They should have decided or planned for the possibility of a COVID disruption in January and not in July. So that is probably on the Commission's, for the Commission's account.
Okay. So just in terms of the finding of the ConCourt's, it also makes a determinant on registration weekend when it must be held, and failure to do so, the minister must then make a proclamation in terms of Section 24, subsection 2 of the Constitution. What exactly does this mean?
Well, it means that in terms of the law, once the election date is proclaimed, there cannot be any further voter registration. So the court declared that original proclamation invalid so that there can be voter registration. If it's possible, there will be a voter weekend registration. Otherwise, until the 10th of September, people can go to the municipal office and register. Once that is completed, the minister will then again proclaim the election, after which the voters' roll will close as required by the legislation.
Okay, so how important is this precedent, this exercise that we've undergone as a country, given the fact that tampering with the Constitution has always been looked down upon, and the intentions have been judged nefarious by those who've been against the application?
Yes, so the problem is that this is a larger problem than just this case, is that people tend to want to resolve problems by going to the Constitutional Court for issues that the Constitutional Court really shouldn't be involved in. This was going to be a postponement and really an indirect amendment of the Constitution, which democratically elected Parliament should do. The unelected judges shouldn't really be asked to do so. So in that sense, I am relieved that the court made the decision it did. We'll have to look at the reasons to see if it's good, if these are good reasons, but in principle, it is, for me, it is a pushback against people who want to implicate the court more and more into really political decisions that is not in the legal realm.
Well, thank you so much for speaking to us. Constitutional law expert, Professor Pierre de Vos, thank you so much for speaking to us. Let's speak